opportunity to attend my talk. And my name is Wentao, I'm a third-year PhD student in MIT. Today I'm going to talk about the dedicated docket in US immigration court. I'll present an analysis of its efficiency and fairness. So this is a joint work with my PhD advisor, Daniel. To start with, I want to give some background information of the refugees and asylum seekers in the United States. According to USCIS, refugees are generally people outside of their country who are unable or unwilling to return home because they fear serious harm. But to seek referral for refugee status, you must be outside of the United States. There has been recent effort in the e-concierge and our community to try to improve the refugees return to the United States and other problems, in particular on the refugee resettlement problem. The focus is on finding a better matching between refugee and located within the new country, so that we improve the resettlement option. There will be a fantastic work presenting in track this afternoon. The focus of my talk will be different and will be on the asylum system. In particular, asylum status is a form of protection available to people who meet the definition of refugee, but who are currently within the United States or are seeking admission at the port of entry. To get asylum, there are two ways. The first way is through affirmative asylum, where an asylum seeker applies for asylum before there is any removal effort by the government. So the asylum seeker needs to submit an application to USCIS and get into with them. Another way includes defensive asylum, where an asylum seeker tries to defend themselves against any removal effort, like claiming they satisfy asylum status. So they need to go through several court hearings to prove that they merit asylum, i.e., meet the definition of refugee. So a judge in the immigration court will decide whether the asylum seeker is satisfied or not for an asylum status. This talk will be focused on the defensive asylum system. In particular, we are looking at the process at the immigration. This area has received a heated discussion in recent years, mainly because of the extensively long backlog in the immigration system. So this talk, I'm showing the number of pending asylum cases in the immigration court for recent years. As we can see, the trend is for it to keep on growing, and the most recent data shows that there are about 1.1 million of pending cases in the group. The long backlog directly translates to a long delay. And here I'm showing the average days waited since court filing for a case that are currently in 30 years. So for a case that are currently in 2021, that case has waited for at least 3 years to get to the hearing. In light of this long backlog and long delay issue, in 2021, the Biden government announced to implement the dedicated docket process for more efficient immigration hearing. And the goal for them is to do it in a promptly and fair way. So what it entails operationally is as follows. In general, asylum seekers will join a regular docket to wait for court hearing. And as I mentioned before, this will take years of waiting. The new program will introduce a fast track docket or fast track queue, where some people will join the dedicated docket, and the policy goal is for all cases to be heard within 300 days since their application. And similar programs were implemented or are implemented, like across different places. In 2014, the Obama government implemented a similar thing, which they call a rocket docket. And in 2019, the Trump government also has a similar procedure of fast-tracking certain asylum seekers' application. And also in Sweden, they have a strategy for processing asylum requests, like they try to fast-track unjustified asylum cases. So this kind of fast-tracking is not unique to the dedicated docket process. But for today's talk, I will focus on that too. Okay, so the entire program seems to try to address the long backlog and is reasonable, like to try to control the delay within a shorter time frame. Although it seems like beneficial to asylum seekers, there has been a huge pushback from the legal and medical community. According to a press release announced by the Bar Association of San Francisco, legal and medical professional call on Biden to end the dedicated docket. In particular, the dedicated docket undermines fairness, prioritizing expediency with no other perceptual benefits, and ultimately result in families being ordered removed to the very dangerous level. So what happened? Here I'm showing a report from the Transactional Record Access Hearing House. It's a research institute in Syracuse University studying immigration issues. So they show that for cases on the dedicated docket, they receive a significantly lower asylum rate. The number is like 28% versus 52% for cases on the regular docket. And there are two law schools who try to investigate what happened. Here, I will focus on the report by Harvard Law School and UCLA Law School. So they look at the dedicated docket in Boston and in Los Angeles and try to understand what causes the poor outcome for cases on the dedicated docket. What the Harvard Law School report found out is that for cases on the dedicated docket, 100% of them, like who eventually obtain asylum, had access to legal counsel. So legal representation is kind of crucial to get asylum. But the fact is that many cases are unrepresented. For the Los Angeles dedicated docket, 70% of them are unrepresented, while the number is only 33% for cases on the regular docket. And the same thing happened in Boston, where like half of the cases on the dedicated docket were unrepresented. But for the entire immigration court, that number is only like 13%. So you need like 100 minus 8%. So why there will be such a contrast between representation of cases on dedicated docket and regular docket? According to the Harvard Law report, lawyers are complaining about the difficulty of properly and effectively preparing an asylum case within the expedited timeline while balancing other cases. So they are hesitant to take on a dedicated docket cases because the timeline is just so stringent. To summarize, representation is almost necessary to obtain asylum. The lawyers are kind of hesitant to take on a dedicated docket case. So these two combined kind of explain the very poor outcome. But as I mentioned before, there is kind of a lot of government effort to push this kind of fast track system. So motivated by this kind of contrast, in our paper we try to address these two questions. First, does it ever make sense, at least operationally, to have such a fast tracking system inside the asylum adjudication? And second, are the previous concerns of the dedicated docket raised by the legal or medical community fundamental to such benefit? What I mean is that, is it kind of necessary for any benefit of the dedicated docket to bring some unfairness? Okay, through a stylized model, we answer yes to both questions. It is operation, sorry. I don't want to, let me just turn off all the clock. I don't want to. Okay. Yeah, so go back here. We show that through the stylized model. Yeah, sorry.
So just a clarification question. How are people chosen to be put on this dedicated?
Yeah, this is a good question. So in fact, the government will have a routing policy to decide what type of asylum seeker to join which docket. So people do not generally have a choice to decide which docket to join. It's more of a government decision. Yeah. And question? Yeah.
Okay, so like misalignment probably. I don't know what it is, but like maybe, I mean, for an asylum, it's good to have more time before the case like get considered, but maybe it's not the case so much for the government. It's just like there's a misalignment of goals. Let's call it that.
Yes.
Right?
So, yeah, you pinpoint a very fundamental point here. So I'll talk about that later. But in general, it's not about misalignment, but it's more like there are multiple objectives. When you prioritize one objective too much, you will harm the other one. So I'll go to that one later. Any other question? All right, if not, let's jump to the model where I will explain more on the objective. So in our model, there are different types of asylum seekers arriving into the system. We assume they have different arrival rate, and types are differentiated by the probability that an asylum seeker may merit asylum, i.e. whether the asylum seeker meets the definition. When the asylum seeker come into the system, they either join the regular docket or the dedicated docket. Meanwhile, they will try to find legal representation. But since there are very limited number of lawyers inside this country, many of the asylum seekers need to wait for legal representation. Okay, and if the court date arrives before a lawyer takes on an asylum seeker's case, we assume that the case will be denied asylum automatically. This kind of reflects what I mentioned before, legal representation is crucial to get asylum. On the other hand, we also assume that if a lawyer takes on the case but does not finish before the court date arrives, we also assume the case will be automatically. This is an assumption we made. In our paper, we will relax this assumption, but our result are kind of proof. And if a lawyer takes on the case and finish before the court date, we assume the judge will make a correct decision. I.e., if the case does not merit asylum, then the court will just deny the asylum. But if the case merits asylum, the court will just grant asylum. But as we can see, for the first two cases, like if court date arrives before a lawyer takes on the case, or a lawyer does not finish preparation before the court date, and if the case is not merit asylum, the court will make incorrect decision. Like the court will wrongly deny the asylum, although the case may merit asylum. And this happened because the case does not have a sufficient legal record. And we assume that the policymaker tries to address this kind of inaccuracy. In particular, we assume policymaker can adjust its routing policy on like which case to join either the regular docket or the dedicated docket, and also set a suitable delay target here in order to achieve the three objectives. The first one is to minimize backlog, because backlog is kind of serious nowadays. And the second one is to maximize the accuracy, which in our model is equivalent to maximize the number of granted cases. Because if a case does not merit asylum, it will never get asylum in our model. The final goal is to ensure fairness, which is kind of a ambiguous term here. Like, what does fairness mean? So I will go back to this term later. For the time being, let's focus on the first two objectives: minimize backlog and maximize accuracy. But as we can see, this is kind of a multi-agent system. Whatever the policymaker does will impact the court's decision and lawyer's decisions. In our model, we assume court has a kind of like a two MM1 queue. The first queue is the regular docket, the second one is the dedicated docket. Each of them has a constant arrival rate determined by the policymaker, and there is a delay target also determined by the policymaker. What the court could do is to allocate its limited number of judge capacity to the two dockets in order to satisfy the delay target for the dedicated docket, and also to minimize the aggregated delay. On the other hand, for lawyer, we model it as a two-class multi-server system with a banner. What I mean is that lawyers will try to select cases to maximize the rate of granted asylum. And each case will take a fixed time to fully prepare. What's unique here is that a case may abandon the system because its court date has arrived. So if a case is still waiting here, but its court date has arrived, there is no need to like wait further because the case needs to go to see the judge. Okay, so considering both the downstream effect on the court and the lawyers, policymakers need to find appropriate decisions to achieve the three goals.
So I had a question.
Yeah.
There is another policy decision one could make, right? Which is for the lawyers mandate that they take on a certain number of dedicated dockets a year or something.
Yes, there is one possible. So if I understand correctly, you mean that for the government, to maintain certain quota for the lawyers, like to take the medical. Yes. First of all, I'm not sure whether the government has the motivation to do so. And second, from the lawyer's perspective, it's kind of a stringent requirement for them. It kind of deprives their own automatic decision. Yeah, but I'm not sure. Maybe it's possible, but currently it's yeah. Okay. Now, let's look at our model and look at the first two objectives. We want to both minimize the backlog, we also want to maximize the accuracy. Is it possible to achieve both of them? The answer is no. There will always be a trade-off between them. So let's look at a simple setting where there's only one docket, which is kind of the traditional case where there's only one regular docket. But we assume the policymaker can arbitrarily hire or fire a judge to make the call faster or slower. Let's imagine the policymaker tries to make the call faster. It will reduce the delay, but it also reduces the preparation time available for lawyers, which means accuracy will reduce. So intuitively, there will be a trade-off between delay and accuracy, and we formalize this intuition by obtaining an explicit relationship between delay and accuracy via freedom of information. So this is kind of mathematics, so I'll skip it here. But at least we can look at some numerical results. So here I'm plotting the relationship between delay and accuracy. To have a higher accuracy, you need to have a longer delay. But that trade-off will be improved if you have more lawyers. That kind of makes sense. If you have more lawyers to prepare, it's fine. And our next question is then, our next question is that, will the introduction of a fast-tracking queue improve such trade-off? So here I'm only showing a single docket case, whether a fast-track queue can improve it. We answer affirmative to this answer by stating the following theorem. In particular, given a sufficiently large Q-length queue, there exists PM decisions for the two docket system, such that the combined Q-length record is equal to Q, and the accuracy is strictly higher than a single docket with the same Q-length. And notably, this result holds even when all asylum seekers have the same probability of meriting asylum. So it does not need to distinguish the type of asylum seeker. And let's look at some numerical results. Here I'm showing that by introducing a fast track docket into the system, the accuracy can improve by about like 10% under certain settings. So what it means is that 10% of asylum seekers that would have been wrongly denied by the court would now gain asylum correction. And similar improvement can be observed when asylum seekers are homogeneous, but the improvement is kind of smaller now because like there is not much heterogeneity the two docket system can explore.
So these experiments are on the data generated base.
Yeah, so let me explain it a little bit. So we have a mathematical model and we try to calibrate the model using some aggregated data. That is like, we know how many asylum seekers are arriving to the country each year. In general, how long it will take for a lawyer to prepare a case, but it's not on a more granular extent. Yeah. So why is that? Like, what is really the benefit? Let's think about a very simple example where initially there's only one docket and the wait time is constantly equal to 200 days. And it takes a lawyer 500 days to fully prepare a case. So in this scenario, nobody on the regular docket can get fully prepared, so the accuracy is pretty low. Now let's think about introducing a fast track docket where the constant wait time is 250 days. By introducing a fast track docket, we also slow down the original docket. In that case, all of the cases on this slower docket will get fully prepared. So the accuracy is kind of like 100%. But for this faster docket, still nobody can get fully prepared. But because it's faster, it kind of draws down the delay. And the benefit of dedicated docket is kind of like it enables such delay differentiation. But as we can see, the outcome is kind of pretty unfair. All the cases on the slower docket get fully prepared. All of them on the faster docket like kind of cannot get fully prepared. Is it fundamental? Really? For reasonable definition of fairness between dockets, a two-docket system cannot improve over a single docket system unless it violates some fairness between dockets. Yeah.
So I think this is an interesting point, but I think it's also worth noting that I don't necessarily care about the people in docket A versus docket B as protected groups for which I would want to have fairness. So it seems like it's an individual level fairness concern, but not a systemic fairness concern. Like it's random, if it's random what docket I get assigned to, then I would prefer that system than a single docket system.
Yeah, that's a good point. That's what I'm going to talk about next. There is a caveat here. This kind of incompatibility result is not true if we only care about the fairness between types of asylum seekers. And the reason is exactly as what you mentioned before. If we just randomly assign people to the single docket and the dedicated docket, there is no unfairness between types. But still there will be unfairness between the two dockets. Yeah, that is kind of the misalignment here. Okay, given that time is coming up, I just quickly summarize. So using a starlight model, we present a trade-off between identification delay and accuracy. And the dedicated docket can help you with such trade-off, but it will entail unfairness between the two dockets. Our work also provide a list of open questions where like how do we calibrate a better or more complicated tree models with more granular data? And how can we create a more efficient asylum system without violating certain fairness? And finally, in our application, there is value of waiting for asylum seekers. Is there other application where there's such a value of waiting, and what is the implication of delay differentiation? Okay, thank you so much. And